Good evening, folks. Welcome to Monday Night Live, episode 3 here. And continuing with our education on just Monday nights with me. Let's see. Hello, Rosa, Ashley, Chad, Lynette. How are we doing tonight? Let's see. Do I get to tag myself? No, of course not. Good evening, folks. All right. Share. Of course. Just copy link, huh? Give me a minute here to get this all going. Let's see if it will let me share to myself. No, it's not letting me. There we go. Man, my phone's being weird. Okay. Man, what the heck? All right. Reload Facebook. Let's see what happens here. Come on. Guess I'll just go straight to my own profile. All right, there we go. All right, let's just minimize that. All right, so we went over episode 1 was the foundation, your basic rights, where do they come from in law, how to find them, where they're at. I posted that on there, showed that on there. You want to go do research on it. That's the thing about those documents. Those are your rights. They're declarations, they're bills of rights, right? So those lay down the law. And you can cite those, quote those, however you want to call it. It's called citing the law. And it behooves you all to, if you haven't watched episode 1, go back, watch episode 1 so you learn where your rights come from in law as it is written. Because if you don't know what your rights are, you can't effectively claim those rights, and most certainly can't exercise them if you don't know what they are. And then episode 2, which was last week, was I was showing you some basic documents. So, you know how to write your notice of special appearance, and eventually I will get a document template up for all of those basic documents. What they would consider a motion, right, for dismissal under Rule 12B, typically speaking. But need to retitle that and call them demands. Demand for proof of jurisdiction and demand for dismissal for failure to prove that jurisdiction. We got to get into comprehending jurisdiction, because there's only we only have 3 jurisdictions here. And it's funny because law, the actual word law, L-A-W, is land, air, and water. Those are the 3 jurisdictions. Those are ancient jurisdictions, which our founders in the Declaration for the Causes and Necessity of Taking Up Arms, which I have in this book, and it's also on Avalon, so you can find those. Hi, Kathy. They talk about extending admiralty and vice admiralty jurisdiction beyond their ancient limits. This is exactly what I'm talking about here, is these ancient limitations on the jurisdictions themselves. In our form of government, we limited the federal government to admiralty jurisdiction. Out on the high seas, the navigable waters, right? Doesn't apply inside the borders of a state. And you cannot extend admiralty jurisdiction onto the land and subvert the law. That's the way our founders set up our form of government. That's right in Article 3. A lot of people get confused when reading the Constitution, especially Article 3. Oh, well, suits at law and suits in equity, blah, 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 blah. Well, yeah, well, that's part of the Constitution. And the Constitution only applies to those that are bound by it. If you're not bound by the Constitution, you're not subject to suits at law and suits in equity, right? Because you're not bound by the Constitution. What we are bound by is the common law. Bills of rights are merely declaratory of the common law. That would be American Jurisprudence, Volume 16, Constitutional Law, Section 100. So knowing the difference between the way England created their common law of England, which was through stare decisis, case law, and how we do it here in this nation called America, our common law is the law that is common to all, which was laid down prior to creating our form of government. So that's the difference between a monarch, the monarch that we separated from, and America, a constitutional republic. There is nowhere in there democracy. We are not a democracy. While we may elect our public servants democratically, that does not make us a democracy. And I keep hearing a representative democracy or democratic republic. No, there is no such thing as democratic democracy. It just doesn't exist in our form of government, right? So what is a republic? Well, let me show you. Article 4, Section 4, so we can all grasp this concept. That what it says as it is written, because that helps to know that where you're citing it from, right here. Article 4, Section 4. The United States shall guarantee to every state in this union a republican form of government, and shall protect each of them against invasion on an application of the legislature or of the executive when the legislature cannot be convened. That would be the president, against domestic violence. Now, those of you in the family law realm of things understand a different term called domestic violence than what it's actually meant and defined in the Constitution in Article 4, Section 4. Domestic violence is insurrection, right? It's not the domestic violence that's being purported today by statute. They've redefined that term to mean something totally different than what it's meant in the Constitution. So, again, there's some parts here that we need to understand. Guarantee every state, notice it's a lowercase s, not an uppercase s, right? That's the people and their status in society in this union. That's what the united means in the United States of America. In order to form a more perfect union, the states, the people, right, and their status in society. Go back to Section 3, new states being admitted by Congress to the Union. These are states that have united, right, in America. So technically speaking, the way it was written was the Constitution for the lowercase u, united, because united is a verb, it's an action. Only nouns get capitalized, right? A person, place, or thing. A union, uniting, the states uniting, is an action, it's a verb. So lowercase u, United States of America. America is the nation. Checking some comments here. Fine, as well. How do we get united? Right here, right now. We're uniting. Are we not? We're coming together. Petitions of remonstrance. Right? That's part of what we teach there on Wednesdays and Fridays. And just so you all know, right here in the First Amendment, right? Congress shall make no law. And to petition the government for the redress of grievances. Now, notice where this right comes from. From the Bill of Rights. This would be a right retained by the people, which means it's not subject to. And again, Congress shall make no law regarding our petitioning the government for redress of grievances, because that right is retained by the people, not government. So Congress doesn't have the authority to make law regarding petitions for remonstrance and redressing our grievances. And then boys over there in Tennessee are going to learn a quick lesson dealing with John Gentry and ourselves, because, you know, we know what we're talking about. See right here, this is part of the talking about the First Amendment. It also guarantees the right of citizens to assemble peaceably and to petition their government. Now, what this, let me break this down, translate this. What that actually means. The right of the people to peaceably assemble. Now, a lot of people say, oh, well, this is, we have the right to freedom of speech and we have the right to peaceably assemble, blah, 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 blah. Well, let me translate what that actually means. We have the right to call the House into assembly. The House and the Senate. The Senate is part of the House. And we have the House of Representatives and we have the Senate, yes. But that's what this petition of remonstrance does. It calls the House into assembly. And in Idaho Constitution, it's Article 1, Section 10. Okay. Whoops. Oh, I missed it. There it is, right to assembly. The people, that's us, shall have the right to assemble in a peaceable manner, to call the House into assembly for what? To consult for our common good, for their common good, the people. People is the subject here. So to consult for the people's common good, we have the right to call the House into assembly. And we have the right to consult with them and to instruct their representatives, because they are servants and we are the masters, right? And to petition the legislature for the redress of grievances, not the judicial and not the executive, nowhere else. the legislature, the House and the Senate, where we establish justice, because we, the people, establish justice, not government. Okay? So we understand why we have the right to instruct our representatives. We have the right to instruct our representatives because all political power is inherent in the people, not government. Government is a figment of the imagination. Government is instituted for their equal protection and benefit, and they have the right to alter, reform, or abolish the same whenever they may deem it necessary through a petition of remonstrance if need be. Because remonstrance means you're challenging bad policy or the actions of a bad actor in government. But this is the reason why you have to go through the legislature when you want to sue these bad actors, because no special privileges or immunities shall ever be granted that may not be altered, revoked, or repealed by the legislature. Okay? So this is why nobody has been successful in filing a Title 42 civil rights claim against a bad actor. 100% pro se litigants cases are dismissed. They automatically do a Rule 12b6 motion for dismissal for lack of jurisdiction. Why? Because that says legislature. The judicial branch actually does not have the authority or jurisdiction to hear our grievances. We've been duped. We've been lied to. We have failed to educate ourselves and read this right here. So knowing this now that I know this, this is what we're teaching and why we're teaching this, how to petition in the form of remonstrance into the legislature. Now, once you know that this is your right and how it works, right, and getting to the how it works part, because of where you're going, you have to know the rules of procedure. A lot of people are familiar with criminal rules of procedure, civil rules of procedure, probate rules of procedure, and family law rules of procedure. But how many of us are familiar? Skip those administrative. Those shouldn't even exist in our form of government. That would fall under admiralty jurisdiction. So we have in Idaho, we have Senate rules, we have House rules, and we have joint rules. So what we look for in the rules of procedure when you want to do a petition of remonstrance for here in Idaho falls under proclamations. As it says, for the purpose of calendars of the Senate and House of Representatives, a proclamation shall be considered a petition. So when you're reading through, when I'm reading through my rules, anytime I see the word proclamation, it is also associated with the petition. Okay? So now that we know that petitions and proclamations are roughly considered the same pursuant to the rules and how they're treated, when we go down here to rule number 6, proclamations, resolutions, and memorials. Now Tennessee calls them petitions and memorials. In my rules, we go by proclamations. So a proclamation, a petition, shall not be printed in the same manner as bills, resolutions, and memorials, but enough copies shall be reproduced so that each member of both houses shall be entitled to a copy, and if the proclamation petition is passed by both houses, copies shall be sent to the entity being addressed by the proclamation. When they're talking about a proclamation, they're just proclaiming something. But in a petition, it's going to be a little bit different. When a proclamation is passed in one house or transmitted to the other, it shall be accepted or rejected only and shall not be subject to amendment. Okay. But when we get into House rules, these are pretty simple rules. These are a lot easier rules to read, comprehend, and utilize than criminal rules, family rules, civil rules, all that. They're not very big. They're pretty short and sweet, right? Notice that they're just like the hour of the time. Okay, rule 1, whoopee. Now you know when they start. 2, what do? They call to order. They call the House to order. The Speaker shall take the chair at the time to which the House stands adjourned, and after the call to order, the roll of members shall be taken and names of absentee. Okay, House chamber and spaces regulation thereof really doesn't have anything to do with us, does it? But check this out. Rule 4. After calling the House to order, the order of business for the day shall be as follows. They do roll call. They do prayer by the chaplain, followed by the Pledge of Allegiance. Every day. This is the process that they go through. Approval of the journal, consideration of messages from the governor and the Senate, board of standing committees, board of select committees, motions, memorials, and resolutions. So you'll notice you get down here, number 14, presentation of petitions and communications. Now, according to their own rules here in Idaho, when a petition is filed, it is to be put on the order of business for the day. And the 14th order of the business for the day is petitions are to be presented. Now, here's the dilemma we have over there with Tennessee is they don't seem to think that we have the right to present our own petitions. Well, let me educate you, Mr. Stevens, out there. Obviously, you're deficient in knowledge on the law and deficient on the knowledge of your own Bill of Rights that you are required by law, ordained and established in the Constitution, Article 6, Clause 3. Right? Let me take you right there so we all get this, because this is something you're going to want to put in your memory bank, okay? Because CPS workers are not, in accordance with the law, bound by oath or affirmation like they're supposed to be. Section 3, the senators and representatives before mentioned and the members of the several state legislatures, so now we're talking state, and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution. Right? And no religious test shall ever be required as a qualification to any office, so that's an elected official, or public trust under the United States. So what we have is we either have elected officials or people appointed into positions of public trust. It doesn't matter what branch of government you're in. You are to be bound by oath or affirmation to support this Constitution, which includes the Bill of Rights, right? Because this Constitution and the laws of the United States which shall be made in pursuance thereof. That is the key phrase of Article 6, Clause 2. Pursuant thereof of this Constitution. If those powers aren't delegated in this Constitution, they don't exist, and that would be an usurpation of power. It would also be an emoluments violations, because you're taking authority or power over something you don't have authority or power over it, because it's not pursuant to this Constitution, right? And all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land. Okay? But who does it apply to again? Those that are bound by it. That tells them what their duties are to perform in their seat in government. And so what we have here now, what's happened is we have a runaway government. They have arbitrarily usurped their powers, created these statutes of statutable plunder, and enforcing them on the people. We call that bills of attainder. That's what our founders called them, right? Article 1, Section 8, Clause 9, or no, it's Section, no, there it was right there. Article 1, Section 8, Clause, no, it is Section 9, there it is. No bill of attainder or ex post facto law shall be passed. What does that really mean? Why are we talking about ex post facto law? Ex post facto means after the fact. After the fact of what? After the fact of laying down the law and ordaining and establishing the Constitution, there is no authority to make law after the Constitution was made, except pursuant to this Constitution. But when we're talking about those kinds of laws, they're not actually the law, right? That would be public law, public policy, which applies to the people that are bound by the Constitution, public servants. In the public, not in the private, where we are. We, the people, are in the private. We're not receiving any emoluments from the government. We're in the private. Okay? Section 10. This is to the federal. This also is a great one right here, because this deals with the immigration stuff issue that we're having right now. The migration or importation of such person as the states now existing shall think proper to admit. Oh, what's that? The states? Not federal? States? Shall not be prohibited by the Congress prior to the year 1808. Uh-oh. Provision of the Constitution right here just says Congress has the power after 1808 to make law regarding immigration. There it is, folks. As it is written right in the Constitution, power over immigration. Section 10. No state shall enter into any treaty, alliance, confederation, grant letters or marquee, reprisal, coin money, emit bills of credit, make anything but gold and silver coin, attainder of payment and debts. Whoa, wait a minute. What did that just say? But that's no state, right? Pass any bill of attainder, ex post facto law, or law impairing the obligation of contracts, or grant any title of nobility. No state shall do that. No state can make any law after the fact of this Constitution. This is where we get into natural rights and civil rights have nothing to do with the establishment, support, or management of government, because that's not what we instituted government for. Right? Because that's what it says. No ex post facto law. Nor pass any bills of attainder. That's statutes, right? That's a statute. Bills of attainder are statutes. Here, you've been attained to pay this bill. You've been charged with a statute. That's a bill of attainder. Can't do that. Legislation that prescribes punishment that bypasses your right to due process of law. Did any of us go and have due process of law to deprive us of any of our fundamental rights and create some of them statutes? No, we most certainly didn't. We didn't give our consent to that. A lot of these statutes were, some of them were made before some of the people were even born. So how is that possible? To even have due process of law to remove those rights. That's why they're called bills of attainder. Now, bills of attainder usually deal with like felonies and putting people to death, that kind of stuff without due process of law. But on the misdemeanor side, bills of pains and penalties is the other term that's used to deprive you of your fundamental rights and deprive you of your right to a trial by jury before they make the statute. So that's why back in the day there in that Declaration for the Causes and Necessity for Taking Up Arms, they talk about the easy emoluments of statutable plunder. That's why they put in the Constitution, no bills of attainder. Let's just do a quick search for bills of attainder so you can see. Let's see what it says. Oh, it says see attainder. There we go. There's kind of a, when a legislative act declares a particular person guilty of a crime, usually treason, such bills are prohibited under Article 1, Section 9 of the Constitution. You know, it's clear as day to me, clear as a bell. You cannot make a legislative act that declares a particular person guilty of a crime. We call them statutes. Color of law. Title 18, subsection 242. So there's your whole freaking family law right there. They may not call them crimes, but they sure are doing something. It's statutable plunder, if you ask me. Again, when we talk family law, natural rights and civil rights have nothing to do with the establishment, support, or management of government. What are you doing? Oh, funny, it actually took me right back to Cornell for that. This is right off of cornell.law.edu, right? Or law.cornell.edu. There's your definition of a bill of attainder. You know, just can't make this stuff up. Let's see, where can I go from right here? Let's go. Bills of pains and penalty. Now see, look, oh, gains? No, I said pains. Okay, pains and penalty. I don't know why it's not coming up more, but if you'll notice, I'm still on law.cornell.edu here. See what kind of stuff comes up when I use this website. There's all sorts of great stuff in here. Let's go look at that when they're talking about William Blackstone. Let's see. Okay, all the restrictions contained in the Constitution. Imagine that. All the restrictions contained in the Constitution of the United States on the power of the state legislatures were provided in favor of the authority of the federal government. The prohibition against their making any ex post facto laws was introduced for greater caution and very probably arose from the knowledge that the Parliament of Great Britain claimed and exercised the power to pass such laws. Statutes. Under the denomination of bills of attainder or bills of pains and penalties, the first inflicting capital, right, and the other less punishment. So capital felonies and less misdemeanors. These acts were legislative judgments and an exercise of judicial power. No, sometimes they respected the crime by declaring acts to be treason, which were not treason when committed. At other times, they violated the rules of evidence to supply a deficiency of legal proof by admitting one witness when the existing law required two. Uh-oh. Imagine that, folks. Here's a good case for you to cite from. Legal maxim. Let me see. I can't remember exactly. Something about the test. It must be the testimony of two witnesses to the same overt act. That's to get rid of that hearsay, right? And they got to have firsthand knowledge. Must have firsthand knowledge, and then you got to have two witnesses to the same overt act. Here it is, right here in this case. The existing law requires two. The rules of evidence require two people to testify to the same overt act. And they have to have first-hand knowledge, right? You can't have somebody claiming first-hand knowledge of something and then say, I told them, so that makes two witnesses. No. The second person doesn't have any first-hand knowledge of what actually happened. They have first-hand knowledge that you told them something, but that doesn't mean that it's true. And this is the problem we're running into today. And let me see if I can make that bigger. There it is. Is that better? A little bit bigger? So there they are, bills of attainder. So right here, I believe the federal and state legislatures were prohibited from passing any bill of attainder or an ex post facto law. I think this is Blackstone. So, and this would be, what is the name of this case? And I'll just go ahead and post it in the link so you all can come right to it. Calder versus Bull. Let's copy that. We'll come over here. Paste that right into there. There you go. Now you can see right where I'm at. That was 1798. Man, that's some good stuff, right? Yeah. Something to read. Counsel for the plaintiffs in error contend that said resolution or law of the legislature granting a new hearing is in the above case is an ex post facto law prohibited by the Constitution of the United States, that any law of the federal government or state governments contrary to the Constitution of the United States is void, and that this court possesses the power to declare such law void. This is what we got to do, right? Yeah, I know. I peruse Justia as well, but when I'm already right here on law.cornell.edu, I just go with this. Number one, this place right here has so much great stuff that supersedes what Justia could even possibly do. Justia just has cases. This has so much stuff. U.S. Code, CFR, you have all these federal rules. There's your UCC, and check this out: law by jurisdiction, state law, uniform laws, federal law, and world law. So not only that, this has the annotated Constitution. You have access to the annotated Constitution. Another thing is like when you type in like bills of attainder, this gives you definitions, and it also links you. I mean, this is how you do research, right? Justia, I don't know if it does that, but one thing I do like about Justia is actually downloading the case file. So you can, when you're looking up, say you find a case in here you like, go over to Justia, pull it up in Justia, and get the case, and then let's see, let's go back. Let's do that. Let's see if it works. A lot of times they'll hide good. Like I found some cases on here that I couldn't find on Justia, but I've also found cases in American jurisprudence that I can't even find online at all. So I don't know, does this actually know? No download. Now let's go like this. Crap. No, stop it. I want just that. We'll go over here. Put it up here in the search bar, and we'll search. Let's see what it comes up with. There it is. Get rid of all them ads. All right, boom. So here's your opinion, which we were just reading from. You go over here and you go case, and then usually it's right here. You can download it. Apparently that's not available on this particular case, which is weird. Is it at the bottom? Well, apparently this one isn't put into PDF for us to download, so. A lot of times. No. Yeah, it's the same one. Dang it. Well, apparently this one isn't downloadable in the PDF form, but yep, you can definitely copy and paste. You can go to your law library and get it. But yeah, you can easily cite from this, whatever it is. Here's your citation in full, right? 3 U.S., 3 Dow, 386, 386, 1798. 386 is the position that we're talking about in this document. When you go to the case part, see that says 387. And you go to 388. So when you go to quote out of section 3 U.S. 388, that's where you would actually cite it at. And you would cite 386, 388 instead of 3. But this is the original citing. That's where the case starts, is on page 386 of 3 U.S. court reports. So probably, I don't know, U.S. Supreme Court citations, reports, court reports. I don't know what 3 dal means. What is that? Weird ass question mark. But there you go. You can see how Justia works. And then you also have Google Scholar, and never even heard of Google Books, legal blogs, any of that. But there you go. In fact, I'm going to leave that up for after the show and go look at that some more. So now that we understand bills of attainders and the fact that we're not supposed to have any titles of nobility, right? No person holding any office of profit or trust under them shall, without the consent of Congress, accept any present emolument. This is Article 1, Section 9, Clause 8. Actually, it's Article, what? Should have been Article 1, Section 9, Clause 8. Oh, it is Clause 8. This is Clause 8. This is where we get the emoluments clause from. Office or title of any kind whatever from any king, prince, or foreign state. Foreign state of being. All right. Let's go back to House rules. Okay, so in the House, what is the powers of the House? Well, we go back to the Constitution, the instruction manual here. We go to the, actually, I believe they put it in, is it in the judicial? Impeachments, where and how tried. Conviction, impeachment of governor. This is for the governor, so this is also the same verbiage for the president out of the Constitution of the United States of America. The House of Representatives solely shall have the power of impeachment. That's the legislative branch. Even though it's listed here under the judicial department, judicial branch, clearly it's telling the judicial branch, you don't have the power over impeachments, right? Except when the governor is being impeached, the Chief Justice shall preside, and only when the governor is being impeached. The court for the trial of impeachment shall be the Senate. The majority of the members elected shall be necessary to a quorum, and the judgment shall not extend beyond removal from and disqualification to hold office in this state, but the party shall be liable to indictment, punishment according to law. This would be the suit at law and suit in equity part, right? This is part of step 2, which is in your petition of remonstrance, right? Because you're demanding impeachment. If you're going after the bad actors, the sole power of impeachment is in the House. The sole power to try all impeachments is in the Senate. Once they're impeached and they go 2/3 of the House votes, right, of the Senate votes, they are to do the trial, right? because that's what it says. This is our instruction manual for our form of government. Go back to Legislative Department. Let's see. There we go. Each house, when assembled, remember calling them into assembly, shall choose its own officers, judge of the election, qualifications, returns of its own members, determine its own rules of proceeding. That's right. Now this is where this book comes in, the Mason's Manual of Legislative Procedure, and sit upon its own adjournments. But neither house shall, without the concurrence of the other, adjourn for more than 3 days, nor to any other place than in which they may be sitting. And I'm going to get back to that over here in the House rules and show you what I'm talking about there. Notice here, Rule 8, petitions, memorials, and other papers addressed to the House shall be presented by the Speaker. That rule is contrary to the right, because we have the right to present our petitions. So we go with Miranda versus Arizona. There shall be no rule making that would abrogate the rights of the people. Congress, legislature, does not have the authority to alter the fundamental law. Fundamentally, we have the right to petition the legislature with the redress of our grievances. Fundamentally, it's in the Bill of Rights. Rights can't be put to a vote, not by the legislature, not in our form of government. That's exactly why we're not a democracy. As Benjamin Franklin said, the question, well, what's the difference between a republic and a democracy? Well, a democracy is like 2 wolves and a lamb voting on what to have for dinner, or voting on to take your bicycle, or to take away your right to petition and remonstrance. But in a republic, it's like a well-armed lamb objecting to the vote. That's why we have the right to keep and bear arms, because that's a declared act of tyranny, legislating for us in all cases whatsoever, right out of the Declaration of Independence. Not in our form of government, thank you very much. Okay. Rule 10, standard rules. Rules of parliamentary practice. Now we're talking about practice. Set forth in Mason's Manual of Legislative Procedures shall govern the House in all cases to which they are applicable, and in which they are not inconsistent with the standard rules and orders of the House and the joint rules and orders of the state Senate and House of Representatives. Now, one of the things here, and I'm going to stop. Now I can just pull it up. Stuff. 10 Commandments. I will have to stop share. I'm going to take you over here to the you don't feel free because you don't know what your rights are and how to properly defend them. That's the problem. You don't know how to stand up to these people properly and say, no, I don't think so. You don't have that authority, and I don't consent to your usurpation of powers. Because what I cannot do in my person, I cannot do through the agency of another. Wait for this. Okay, here we go. All right, so this is something Chris wrote up, part of his parliamentary inquiry that he did. This has the 10 principles of the Mason's Manual of Legislative Procedure. The first principle being the group must have the authority to take the action it purports to take. Jurisdiction must be given. It cannot be assumed. And then they openly admit in the first principle that groups sometimes assume powers they do not have. So in reality, we, the people, having all political power, right, having the right to alter, reform, or abolish anything at any time we deem it necessary, this is the right that Mr. Stevens doesn't think that we have, right? That would be an attempt to deny or disparage other rights retained by the people pursuant to the 9th Amendment. So they're openly admitting that groups sometimes assume powers they do not have. So whose responsibility, whose duty is it to keep that stuff in check? Ours. It's not just a right, it's a duty. We have a duty to say, hey, somebody has exercised some powers that don't belong to you folks. And I'm here in a petition of remonstrance to say, you didn't have that authority to make that policy. Therefore, it is to be abolished. And we don't need to go anywhere, any other branch of government for this. Clearly, the Constitution says one thing, and your policy says another. Okay? And then we get down here to number 9. There must be no fraud, trickery, or deception resulting in injury to another member. Now, granted, they're talking about to another member. Person is entitled to protection of the courts from injury through injustice by a body making a group decision as in any other situation involving injury. That's not true. That would be false. We go to the legislature for that, right? Although, I guess at the suit at law part, because the Senate would order the investigation when they're getting ready to do the trial. If you watch the Kavanaugh hearings, you watch this, how they did that. The Senate ordered an investigation for what? For criminal indictments. Right back to the state constitution where it says that they're not getting away with the fact that they could still be criminally indicted, right? So knowing that, clearly there are more steps. So when they do, the Senate orders that investigation. Who does the investigation? The executive branch does. What are they doing an investigation for? For criminal indictments. So once the Senate reports, or once the executive branch reports back to the Senate and says, yeah, we found these crimes here, and we've got some criminal indictments, we'll make up some criminal indictments, based on what? The evidence that you've supplied in your petition of remonstrance to order that investigation. Or at the bare minimum, the claims that you have made, okay? And we're talking about bad actors, right? So now that you know that you can put your claims in your petition and that the Senate orders the investigation, you can instruct your representatives that you want the Senate to order an investigation for criminal indictments. Now, those criminal indictments come back to the Senate. Yep, we got some. We're ready to go. They just verified your claims. Now the Senate takes a vote to fully impeach and remove this bad actor from duty, and not only that, to remove their immunity. So now they're removed from duty, and here's all these indictments sitting there, and your claims have just been verified. What are your first initial claims? Sure, are claims of trespass of the law and trespassing your property, your rights, and violating your rights, right? But you also have tort claims there, which would be the suit in equity part. So now the executive branch has to appoint a special prosecutor, or the public prosecutor, because that is who the public prosecutor is supposed to be prosecuting: public servants that have been impeached and removed from duty. And now all them criminal indictments are laying there. They go take over to the what? Judicial branch for the suit at law. Remember, these public servants are the ones that are bound by this process. So now it goes over there to the judicial branch for the suit at law. And your tort claims are laying there, right? You're laying claims to the fines that get imposed from those crimes. That's the suit in equity part. So as soon as they're criminally indicted, as soon as they're tried in the judicial branch, now, technically speaking, if your tort claims are already there, there is no need to go into the civil side, right? That's for suits between man and man out here on the street. We're not talking about a man out here on the street. We're talking about a public servant acting in his official capacity that's been removed from his duty. And that's what these other representatives in government are supposed to do. We're not supposed to be subject to their jurisdiction. When they take that oath or affirmation, they're giving their consent to be subjected to that jurisdiction. So now they're sentenced to prison and all these fines, and your claims, your tort claims, are just laying there. Pay me. You go back. Can go back in your petition there, right? It's a bill, a true bill. Now that they've been criminally indicted and tried and found guilty and all these fines are assessed, your tort claims, you go back in with a true bill. Now, this is something I'm still trying to learn on here and put these little pieces together. Typically speaking, we know we go to the judicial branch and we sue them and we get paid. No. We write a true bill. Go back to the rules of procedure. This would be a private law. A bill to get paid. And it goes back through the House and the Senate. And, well, wait a minute. Yeah, we impeached that guy. How'd that turn out over there under the suit at law? Oh, yeah, he was found guilty. And now we're back here for the bill. It's time to submit the bill and get paid. So that's the in essence the actual process. At least as far as I've gotten, and as far as we've gotten with Chris's remittance of his bill. Now there's a little bit of difference between Chris and the rest of us here. Chris has a private corporation. And actually, technically it would be a public corporation, but it's privately owned. It was to provide legal services under Title 42, supplemented by Congress, right? Congress had to supplement Title 42 to create E-Clause LLC to do what? To provide legal services and to provide equal protection under the law. Welcome to E-Clause LLC. It's what we do. So, now we're into this. All right. So, any questions? Try to stick to subject matter here. Talking about dealing with duty. It's our duty. Right out of the Declaration of Independence. Okay, I don't really see any major questions here. Oh, what else can I show you? Actually, let's just close that. All right. Oops. Go back to the rules. Let's go back to some rules. So this is the House rules. I'm going to go back here to the Senate rules, which are relatively the same. But it all starts in the House, right? See, same thing. Hours of the meeting, who the president of the Senate, this all just tells you who's what, does what, and what's a quorum, how it works. Let's see. I know it talks, there it is. Okay. Order of business. Again, they do a roll call, prayer and pledge of allegiance, reading and correlation of the journal. Here we are. Number 10. Motions and consideration of petitions, resolutions, and memorials. Number 11, introduction, first reading and reference of bills, House petitions, resolutions, and memorials. So the House, when they take a vote to impeach that bad actor, your petition comes from the House to the Senate, because the Senate has the sole power to try that impeachment, the bad actor. So there it is in the order of business for the day. And then notice that it has second reading of bills and third reading of bills, consideration of general calendar, miscellaneous business, right? So this is actually going to be quite interesting following what's going on with John Gentry's petition or remonstrance. So okay, how do I get my kids back? Well, that's not really within the subject matter of what we're talking about here tonight. Go back and watch episode 1 and episode 2 if you haven't already. Understanding due process of law, how to do a notice of special appearance subject to the personal jurisdiction and jurisdiction in general, right? Because if they don't have jurisdiction, they don't have that at all. And then if they want to skip over that, I showed you how to give affirmative defenses, counterclaims, and cross claims. That's the reason why I'm doing these. People have that same exact question. That's why I'm doing these in order, so you can learn this stuff. My petition is not fully done yet, so I'm still working on mine. I'm working on Bob's. I'm working on Brian's. Yeah, my plate's pretty full. So the key to getting your kids back, to be honest, follow the law. Fire your attorneys, because their first line of allegiance is to the court, and then to the public, and never to you. So that's part of the confidence scheme, confidence scam, confidence trick. All right, Melissa, I may take you up on that. Yep. Yeah, definitely super busy, Tanya. And I hope Chris said he was going to try and take some time and help you guys with the stuff there in New York. So, man, I wish I could just clone my brain or something and hand that sucker out like nobody's business. But this is the closest and best thing I can do to spreading the knowledge that I have in my head and getting it out there for the rest of you to at least come back and rewatch a few times until you get it. But which is also why I've started the whole episode deal, trying to go in a chronological order here. And do what I do. I thought Chris said he was something about that, Tanya, you were doing something in New York. Sorry, Ginger. I know. But here it is. You know, this video can be played in Louisiana, or it can be played anywhere. So you can take me everywhere you go, at least in video. Hey, brother, how's it going? Christopher Hallett just jumped on. Oh, what's some interesting stuff I can show you? Let's see. Let's go back. Let's go back over the Constitution. Lots of great stuff in the Constitution. Oh, let's see. So let's start with the preamble. Imagine this. I can't believe this. I laugh every time I see this. The preamble to the Constitution is an introductory, succinct statement, I probably said that wrong, of the principles at work in the full text. Why? Because it's the first clause of the entire Constitution, and I would actually call it the enabling clause of the entire Constitution. It is referred to in countless speeches, judicial opinions, and in a song from Schoolhouse Rock. Right on, law.cornell.edu. Thanks for pointing out the good old Schoolhouse Rock. Courts will not interpret the preamble to confer any rights or powers not granted specifically in the Constitution. Great. We didn't give you the power to interpret jack shit, buddy. You're supposed to follow what we established and laid down and ordained. This is the problem we have. Things like this. There is no interpretation needed on any of this. The courts aren't supposed to be interpreting anything. Either you comprehend the English language or you do not. We don't need people to interpret anything, right? The law is supposed to be written in plain English so that the average man can read it and comprehend it. So we either have an IQ problem or we have an education problem. We don't need anyone to interpret anything. That's the scheme, scam, and fraud again. Oh, well, the courts are the ones that have to interpret that. No. No, thank you. We, the people of the United States, in order to form a more perfect union, establish justice. Well, wait. Let's say that again. We, the people, establish justice. We, the people, ensure domestic tranquility. We, the people, provide for the common defense. We, the people, promote the general welfare. We, the people, secure the blessings of liberty to ourselves and our posterity. We, the people, do ordain and establish this Constitution for the United States of America. Right? So there it is. I don't need anybody to interpret. And I believe the real reason why they don't even like to use the preamble or have anything to do with the preamble, because these are some very set limitations on the government itself and the powers that are retained by the people. Because when the people basically have all the power, what exactly was delegated and granted? Not a whole lot. That's why it's called a very limited government. So actually, let's click on this. Let's see where they take us. Song from Schoolhouse Rock. I wonder if they take us to YouTube. Yep, I think we've been through this before.
About the Constitution. Hey, learn about the USA.
Start that over.
you know about the USA? Do you know about the government? Can you tell me about the Constitution? Hey, learn about the USA. In 1787, I'm told our founding fathers did agree to write a list of principles for keeping people free. The USA was just starting out, a whole brand new country, and so our people spelled it out, the things that we should be. And they put those principles down on paper and called it the Constitution. And it's been helping us run our country ever since then. The first part of the Constitution is called the preamble and tells what those founding fathers set out to do. We the people, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity. Do ordain and establish this Constitution for the United States of America. In 1787, I'm told our founding fathers all sat down and wrote a list of principles that's known the world around. The USA was just starting out, a whole brand new country, and so our people spelled it out. They wanted a land of liberty, and the preamble goes like this. We the people, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity. Do ordain and establish this Constitution for the United States of America, for the United States of America.
All right, let me post that link.
Hey, do you know about the USA?
All right, there you go. In the comment section, there's the YouTube video. Oh, where am I at? Oh, it took me right to it, didn't it? Yeah, it did. There's lots of other Schoolhouse Rock videos there for you, if you ever want to watch those. Right, Kathy? You know, back when I was a kid in the 70s there, this is something I used to watch on the TV. They played them on TV. They don't play them on TV anymore. Yep. Yep. Used to be on the Saturday cartoons. Us old folk over here. We so old. Schoolhouse Rock so old. I seen a comment there by Melissa. She's talking about the corporation thing. Where is it? How about telling them the difference between Constitution, Bill of Rights, and Declaration as opposed to corporation, the United States Corporation versus the United States of America? I think that messes people up all the time, just a suggestion. And who answers to that Constitution, the difference between resident, people, person, and citizen? Great confusion with these facts out there. I know, and that's part of the reason why I try to stay away from that. And my simple answer for all of that, it's an F word, and we all ought to start using it a lot more often. It's called fraud. And fraud vitiates everything, makes it void from its inception, not from the day you go to court and brand it as unconstitutional. So the problem we have is, of course, again, capital felony, treason, usurpation of power. Our Congress, back in the day, many different dates, parts of 1871, the Reconstruction Acts, and 1910, 1913, 1930, 1933, has all converted our form of government, allegedly, into a corporation. The United States of America, which is the capital U, they rewrote our Constitution, right? The Constitution we're looking at even right here, right now, is actually not the Constitution of 1787. It was not written in this format to begin with. So there's that. And then you have United States Inc., INC Incorporated, into what? I don't know what, right? So even in, okay, Melissa, help me out with this one. I think it's 28 CFR 1441, I think it is, that says the United States is a federal corporation. So it's not like they're hiding it. They're putting it out there. Thank you, Michael. Yeah, if you're learning anything here and want to help support me in my endeavor in educating the people and helping people do their petitions of remonstrance and do everything that I do, and help support me, you can make a private personal donation to me through PayPal, which Michael just shared that out there. Thank you, Michael, brother. Appreciate it. And you could also send a check, money order, postal money order, anything like that, to 6477 West Fairview Avenue, Suite C, Boise, Idaho 83705. That's actually on the page there, which, to be honest, not quite sure how much longer I'm going to be there. The 3 offices that we have rented, the attorney and the paralegal that are in the other 2 have decided to, well, the attorney has been offered to move in with another law firm. And I don't know how this is all going to pan out. So, anywho, we'll work something out. May just go back to working out of my home, cut down on the costs of paying for the office. So, right, Frank? All of our of us are ignorant. I mean, I'm still ignorant to a certain extent, right? There's lots of things I don't know out there. So try not to take ignorance being a derogatory comment. It just simply means we don't know a particular thing. So, like, I don't know how to draw. I'm completely ignorant when it comes to drawing. And I'll call it willful ignorance, because no matter how hard I try, I can't draw. My stick figures look bad. So I'm not good at everything. Just so you all know, I'm not perfect. I'm not good at everything. Are you talking about temperature? Minus 30 tomorrow morning, Wednesday minus 35. Ooh, boy. Get your batteries out and get some electric socks and gloves and long johns or whatever. Holy smoke, that's cold. Well, Joseph, you got one up on me if you could draw good stick figures. Minus 60 with wind chill here. Oh my goodness. I can't cut hair. Oh, I can cut it all right. I'm not going to say it's going to be good. All right, folks, with you having those kind of temperatures, holy smoke, bundle up. Hopefully you don't lose power. You might want to get some propane accessories. Thank you, Kathy. So, yeah, you all might want to run out and get some propane accessories, a cook stove, something, propane heaters. If you're having that kind of temperature, you guys might lose some power. Hopefully that doesn't last too long, but yeah, I suppose you people there that have been there a while, been through this before, probably already have that kind of stuff, but you know. Well, not when they're inside. My haircuts look like Kirk stick figures. Oh my goodness. It gets so cold you can spit and it freezes before it hits the ground. Man. All right, so let's kind of get back to some constitutional law. Oh, let's see. I really like going to these C explanation stuff. I've shown this before, but I like showing it again so we can all understand that our rights go clear back to the Magna Carta. This is dealing with the right to a speedy trial, speedy and public trial. The Magna Carta declared, "We shall not sell to no man, nor deny or delay justice and right." Right? Notice that that's what we're talking about there. Much the same language incorporated in the Virginia Declaration of Rights. That's because that's our theoretical foundation of all government. That's our ideology of this nation, laying down the law, declarations. And from there into the Sixth Amendment. Now, that just shows you that little piece tidbit there, which is actually, I showed went in depth on that on the first episode. So if you missed that, go back to that. Let's get into the Ninth Amendment. Let's see some explanation on the enumeration in the Constitution of certain rights shall not be construed to deny or disparage other rights or others retained by the people. Okay. The Federalists contained a Bill of Rights. I wish there was a way I could move that sucker, make these a little bit bigger. Oh, wait, now I can. Oh, wait, no. Doesn't move it any bigger, I guess. All right. Contended that a Bill of Rights was unnecessary. They responded to those opposing ratification of the Constitution because of the lack of a Declaration of Fundamental Rights by arguing that inasmuch as it would be impossible to list all rights, it would be dangerous to list some and thereby lend support to the argument that government was unrestrained as to those rights not listed. So there was actually a few states that would not sign on to ratifying the Constitution unless we had a Bill of Rights, which is why they say in Article 7 that 9 states shall be sufficient. But technically speaking, the Articles of Confederation do not allow 9 states to ratify anything, because it says all of them must ratify it and agree to the change. So that, in my mind, as it is written in Article 7 of the Constitution here, would be an usurpation of power and fraud upon the people. So Madison averted to this argument in presenting his proposed amendments to the House of Representatives. It has been objected also against a Bill of Rights that by enumerating particular exceptions to the grant of power, it would disparage those rights which were not placed in the enumeration. And it might follow by implication that those rights which were not singled out were intended to be assigned into the hands of the general government and were consequently insecure. This is one of the most plausible arguments I have ever heard against the admission of Bill of Rights into this system, but I concede that it may be guarded against. I have attempted it, as gentlemen may see by turning to the last clause of the 4th resolution. It is clear from its text and from Madison's statement that the amendment states but a rule of construction, making clear that a Bill of Rights might not by implication be taken to increase the powers of the national government in areas not enumerated, and that it does not contain within itself any guarantee of a right or a prescription of an infringement. In 1965, however, the amendment was construed to be positive affirmation of the existence of rights which are not enumerated, but which are nonetheless protected by other provisions, such as marriage and parental rights, because marital rights and parental rights have nothing to do with the establishment, support, or management of government. And in my Idaho Code, Title 32, Chapter 1010 there, even says that parental rights are deeply rooted in our nation's history and are among the unalienable or unalienable rights protected by the 9th Amendment. Okay, that takes that right out of the jurisdiction of the state, does it not? Both state and federal. This is part of the reason why the federal courts will not take jurisdiction over parental rights. When you try to file suit, well, nope, denied. We don't have jurisdiction over that. Well, I really think it is just they don't want to hear it. But they'll sure take jurisdiction over everything else, right? The 9th Amendment had been mentioned infrequently in decisions of the Supreme Court until it became the subject of some exegesis by several of the justices in Griswold versus Connecticut. Notice that says number 5 there. It'll take you right to that, but it's down in the footnotes as footnote number 5. And that's one reason why I love this site. And notice what we're looking at here. This is the annotated Constitution. Right there, U.S. annotated Constitution. The court in that case voided a statute prohibiting use of, oh boy, this is good. The court in that case voided a statute prohibiting use of contraceptives as an infringement of the right of marital privacy. Okay. If the state can't make a statute prohibiting the use of contraceptives because it violates marital privacy, what the hell are you doing creating a marriage license contract and creating Title 32 in the Idaho Code, domestic relations, reaching into the homes of people when you can't even prohibit the use of contraceptives? Kind of makes you wonder, huh? Specific guarantees in the Bills of Rights have penumbras formed by emanations from those guarantees that help give them life and substance. Thus, although privacy is not mentioned in the Constitution, actually it really is, the Fourth Amendment, the right to be secure in our persons, papers, houses, and effects, that's your right to privacy, is not mentioned. It is one of the values served and protected by the First Amendment through its protection, associational rights, and by the Third and the Fourth and the Fifth Amendments. There it is. Third, Fourth, and Fifth Amendments, right? As well. So that, you know, you can plug in all these other rights all at the same time. The justice recurred to the text of the Ninth Amendment, apparently to support the thought that these penumbral rights are protected by one amendment or a complex of amendments despite the absence of a specific reference. Justice Goldberg, concurring, devoted several pages to the amendment. The language and history of the Ninth Amendment revealed that the framers of the Constitution believed that there are additional fundamental rights protected from governmental infringement, which exist alongside those fundamental rights specifically mentioned in the first 8 constitutional amendments. To hold that a right so basic and fundamental, so deep-rooted in our society as the right of privacy in marriage may be infringed because that right is not guaranteed in so many words by the first 8 amendments to the Constitution is to ignore the Ninth Amendment and to give it no effect whatsoever. So, because of that, and I'll just pop this sucker up because it's so easy for me to find because I've been there so many frickin' times. I'll just take you right there and show you what it says in mine. See, that says domestic relations. What the heck is domestic relations? That would be interfering with our fundamental principles, right? Here we go. Title 32, Chapter 10, subsection 1010, intent of the legislature, parental rights. The interest and role of parents in the care, custody, and control of their children are both implicit in the concept of ordered liberty and deeply rooted in our nation's history and tradition. They are also among the unalienable rights retained by the people under the Ninth Amendment to the Constitution of the United States. I didn't write it. It's right there. The interests of the parents include the high duty and right. It's a right to nurture and direct their children's destiny, including their upbringing and education, not the government, right? Because it's protected by the Ninth Amendment. It has nothing to do with the establishment, support, or management of government. It's not what we instituted government for. The state of Idaho has independent authority to protect its parents' fundamental right to nurture and direct their children's destiny, upbringing, and education. That's a fundamental right. We have the right to direct that, not government. The protections and rights recognized here are rooted in the due process of law guaranteed pursuant to Section 13, Article 1 of the Constitution of the State of Idaho. I've showed this before, but let's go right on over there. Let's go right there to Article 1, Section 13. We're talking about due process of law, talking about the law of the land. And it says guarantees in criminal actions in due process of law. Notice that it says and. In all criminal prosecutions, the party accused shall have the right to a speedy and public trial. Notice that, speedy and public trial. Didn't I just take you that over there? Your right to a speedy and public trial. Source and rationale came all the way back from the Magna Carta, Section 40. To no man will we sell, to no man will we deny or defer rights or justice. To have the process of the court, to compel the attendance of witnesses in his behalf, and to appear and defend in person and with counsel. That doesn't say with an attorney. No person shall be twice put in jeopardy for the same offense, nor be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law. It must be criminal in nature, and you have to follow criminal due process of law to deprive life, liberty, or property. And you have to have a trial by jury unless you consent otherwise. That would go right back to the Sixth Amendment. All right, let's back up just right back over here. Governmental efforts that restrict or interfere with these fundamental rights are only permitted if that restriction or interference satisfies the strict scrutiny standard provided in this section. Okay, here we go, CPS people. You want to know how about getting your kids back, which we're running out of time, and I wasn't fully prepared to do that, so that'll be next week's episode. Okay, but let's go over there to that strict scrutiny standard. Neither the state of Idaho nor any political subdivision thereof, would be CPS, may violate a parent's fundamental and established rights protected by this act. Well, got to go through criminal procedure, and you have to follow due process of law in accordance with Article 1, Section 13 if you're in Idaho, because that's the legislative intent. Although Idaho code is not law, I still can go with that because I agree with that, and that's just a true statement. Parental rights are deeply rooted in our nation's history, and they're protected by the Ninth Amendment, fundamentally. So, they cannot violate a parent's fundamental and established rights protected by this act, and any restriction or interference with such rights shall not be upheld unless it demonstrates by clear and convincing evidence that the restriction or interference is both. No. When we're talking criminal, it's beyond a reasonable doubt. It's not a clear and convincing. It's beyond a reasonable doubt. So, anywho, essential to further a compelling governmental interest and the least restrictive means available for the furthering of that compelling governmental interest. The foregoing principles apply to any interference, whether now existing hereafter enacted. Nothing in this act shall be construed as invalidating the provisions of the Child Protective Act. Oh, no. I don't care what you create. Cannot fundamentally trespass the law, trespass upon our rights, our property, which is an aggregate of guaranteed rights, the parental rights that are deeply rooted in our nation's history. This is an oxymoron. This is more of that word salad trying to give themselves authority, right? Oh, but we can still do this over here. Even though we're saying all this over here, we can still do that over here and fundamentally alter our form of government. No, you cannot. Okay? When a parent's fundamental rights protected by this act are violated, a parent may assert that violation as a claim or defense. Claim. Affirmative defenses. In a judicial proceeding, and may obtain appropriate relief against the governmental entity. If a parent prevails in a civil action against the state or a political subdivision thereof, as provided in subsection 4 of this section, the parent is entitled to reasonable attorney fees and costs. Screw that. But anywho, we can jump over here real quick because I know that this shows Here we go. Policy. Policy is not law. Policy is for members of a corporation. Right? Policy. This is where they're trying to impose McDonald's policy on you, on us. The policy of the state of Idaho is hereby declared to be the establishment of a legal framework conducive to the judicial processing. What? Word frickin' salad right there. Including periodic review of child abuse, abandonment, neglect cases, and the protection of any child whose life, health, or welfare is endangered. At all times, the health and safety of the child shall be the primary concern. No, because right back at the legislative intent, that's a high duty of the parents, not government. And that's why it's protected by the Ninth Amendment. And again, has nothing to do with the establishment of public policy and imposing that as having the full force and effect of law onto the people. That's more like fraud. That's color. This is color of law right here. Each child coming in with the purview of this chapter shall receive. Well, this chapter ain't even supposed to exist, right? Preferably in his own home. Okay, here we go. This is where we get into it really good. Now, this is the kind of stuff you can use against them. You want to get your kid back? Watch this. The care, right, supposed to be, as it is written according to their policy. This is how you beat them up with their own policy. Each child coming with the purview of this chapter shall receive, preferably in his own home, the care, guidance, and control that will promote his welfare and the best interest of the state of Idaho. Best interest of the state of Idaho. State of Idaho is that doesn't even exist. So how can there even be a best interest of the state of Idaho? And if he is removed from the control of one or more of his parents, guardian, or other custodian, the state shall secure adequate care for him, provided, however, that the state of Idaho shall, to the fullest extent possible, seek to preserve, protect, and enhance and reunite the family relationship. Nothing in this chapter shall be construed to allow discrimination on the basis of disability, blah, 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 blah. 1, preserve the privacy and unity of the family whenever possible. Take such action as may be necessary and feasible to prevent the abuse, neglect, abandonment of homelessness of children. Take such actions as may be necessary to provide the child with permanency, including concurrent planning. Clarifying for the purpose of this act the rights and responsibility of parents with joint legal and joint physical custody of the children at risk. Maintain sibling bonds by placing siblings in the same home when possible, and support or facilitate sibling visitation when not, unless such contact is not in the best interest of one or more of the children. Now, I can't quite remember where it was that I found that last time, where it was talking about, and it may still be right in here somewhere. I swear that I went in here and looked for this before. And that's part of the reason why I didn't want to do this tonight, because I wasn't fully prepared to do this. I did look again the other day. I should just go back and watch the video that I did it in and showed it. But it might be it right here. Any physician, resident officer, nurse at school believing a child under 18 years old has been abused, abandoned, or neglected, who observes the child being subjected to conditions. Notice it says, who observes the child being subjected to conditions or circumstances, firsthand knowledge, physically observing, that would reasonably result in abuse, abandonment, or neglect shall report or cause to be reported within 24 hours such conditions or circumstances the proper law enforcement agency or the department. Law enforcement agency. The department shall be informed by law enforcement of any report made directly to it. If the department knows or has reason to know that an adult in the home has been convicted of lewd and lascivious conduct or felony injury to a child in the past, or that the child has been removed from the home for circumstances that resulted in a conviction for lewd and lascivious conduct of a felon injury to a child, then the department shall investigate. Only if they've been convicted for lewd and lascivious conduct or felony injury to a child, then the department shall investigate. Right? Means they had to have gone through criminal procedure. When the attendance of the physician and resident attorney shall know the probation in charge institution is designated delegate who shall make the necessary reports. Okay. Purpose subsection 3 of this section, the term duly ordained minister religion, blah, blah, blah. I really want to find that one part where it lays down that they have to actually contact the attorney general or a prosecuting attorney. That's law enforcement. Here's where you have the right to sue them if they report in bad faith for civil damages. More SMU. Maybe it was in, no, it wasn't. This is where I was just at looking again. Child may be taken into shelter care by a peace officer, not a social worker, without an order issued pursuant to section 4 of 1611 of section Idaho Code, only where the child is endangered in his surroundings and prompt removal is necessary to prevent serious physical or mental injury to the child, or the child is abandoned, child pursuant to the provisions of that. Right? An alleged offender may be removed from the home of the victim of abuse or neglect by a peace officer without an order issued pursuant to only where the child is endangered and prompt removal of the alleged offender is necessary to prevent serious. What we're talking about is life and death. Okay? I'm not quite sure of any kind of mental injury that causes serious life and death threatening situation mentally. When a child is taken into shelter care, may be held for a maximum of 48 hours, excluding Saturdays, Sundays, and holidays, unless the shelter care hearing has been held pursuant to section 16-1615. So it lays some of this stuff out here, and you kind of got to dig, right? Maybe let's go here real quick. Man, I wish I could find it where it was talking about that. Oh, man. I will have to do that on another date and time. And I'll do a whole show on just that particular stuff and certain documents to write, which goes back to episode 2. We'll tie into episode 2 on writing these documents, because this is the kind of information that you'll want to put in there when I find this again. Because we're running out of time tonight. Oh, this is for abandonment. But, yeah. I'll find it again and I'll lay it all out there again. Someday. Yeah. Oh, if a preponderance of the evidence at the adjudicatory hearing shows that the child comes within the court's jurisdiction, what jurisdiction? Law of the land, law of the air, law of the water. Court don't have jurisdiction. It's just this stuff. This stuff hurts my brain sometimes. How they write this stuff and purport this stuff onto the people. The part that I'm looking for was it was talking about a voluntary agreement, which is the contract that they can do all this, and that's the part that I highly recommend that you rescind if you've ever signed that agreement with them, which under duress, threat, and coercion, which I've heard from several people, if you don't sign this contract with us, this parenting plan, we're going to keep your kids. No, that's fraud. That's a violation of several elements of a lawful contract, depriving you. It's under duress, right? Well, if I don't sign this, they're not going to give me my kids back, and well, they don't intend to give you your kids back anyway, right? They're all wanting money. They want that Title 4D and 4E money for foster care and all that other good fancy stuff. And that's the funny part. The Title 4D stuff, $16.7 billion is allocated yearly in the budget out of Title 4D to provide all these fancy programs to keep families together in the home. And that's part of what's in that parenting plan that they're supposed to pay for, right? Because that's what that money is for. That's what that Title 4D money is allocated to. They don't want to tell you that either. Oh, well, you have to pay for it. No. No, that's what this is all about. If you're going to go that route and play that game, then you provide those services in accordance with Title 4D where you're getting your money from. Nope, Title 4D, just one section of Title 4D is $16.7 billion per year. And that's just one part of Title 4D. But you read it in there, and it tells you, breaks it down. Stuff for fathers, stuff for families. It's all sorts of counseling and all this stuff that this money is allocated to reimburse the states from the tax dollars from the states that are spent that are supposed to be doing this already. You know, it's, yeah. I know, right, Frank? So it makes you wonder where, I mean, these are all emoluments violations, right? They're getting all this money and they're not spending it. And they're still taking our kids, your kids, my kids, not necessarily mine, but, yeah, like bogus supervised visits, right? That's supposed to be part of the Title 4D funding. But why would you need a supervised visit? Again, I'll have to dig this all up again and do next week's show, dedicate it to just this particular part and how to write those documents to get this back into court if you got a CPS case. Teach you how to kick their butt. All right. So thanks for tuning in. Like, follow, and share here on Kirk's Law Corner. Again, if you'd like to support me, do the PayPal there. Kirk_Pendergrass@hotmail.com is my PayPal. And, we have Kirk's Law Corner group. In the files section, there's all sorts of files in there. There's the E-Clause LLC group, used to be formerly known as Amber and Steven. Christopher Hallett runs that group over there. There's the Steven page, which Chris goes live from there too. He does little videos out of there that's well articulates some of this emolument stuff and the petition of remonstrance. And I mean, we're all trying to do anything and everything we can when we have time, even independent of each other, to put this as much information as we can out there. I'll speak for myself. I feel for you folks out there that have had your kids taken, but I want to let you know, in 1985, I was the child that was kidnapped, right? For those of you who are not aware of that, I know I don't share it very often, but in 1985, 14 years old, just before I turned 14, my family got destroyed, ripped apart, spread across the United States, and was told by my caseworker that, oh, well, if my mom wanted me back, I'd already be back home by now. That's at 14 years old in 1985. I can't even imagine how much worse it is now today in 2019. I've heard hundreds and hundreds of, if not thousands of stories in the last 2 to 3 years from folks like you out there that have had your kids stolen, kidnapped. It's so wrong. I know it is. And that's why we feel for you and why we're trying to do what we're doing. We're trying everything we can to help educate and help as many people in mass at the same time. We really don't have the time to help people on an individual basis. The ones we are helping on a somewhat individual basis, our time is taken up by doing that. We don't even have time to make phone calls and call you and talk to you on an individual basis. Some of you, and more, how long did it take for me to call you? Several of you have asked me to call you. There's just not enough hours in the day. There just isn't. And I got to have some downtime for this because it'll drive me crazy. And, sometimes I get really big bags under my eyes because I can't sleep. I'll sit here and read and read and read, trying to learn more and more stuff to share with you people. I do what I can. That's all I can say. Much love, hugs and love out there, folks. Doing what I can. I need you guys to pick up a Constitution. I need you to pick up that Declaration of Independence and read it. I need you to read the Constitution of the United States of America. I need you to read the Bill of Rights. I need you to read your state constitutions and read that stuff and comprehend what's in there, what your rights actually are, even in your own states, right? That stuff is in there. And when you know that stuff, knowledge is power. It will literally empower you. Because once you know, nobody can pull the wool over your eyes, right? I don't care what costume they're wearing, whether it's an attorney costume, whether it's a law enforcement attempting to appear as law enforcement. That's that disguise they talk about in Title 18, Section 242, going out on the streets in disguise, because all men are created equal. So, well, make sure you're reading the right kind of law, folks. The Constitution, your Bill of Rights. That's where you need to start. Fortunate for me here in Idaho, my Secretary of State prints out the law. And notice you won't see the Idaho Code on here because that's not law. This is. See that? Constitution for the State of Idaho, the Declaration of Independence, and the Constitution for the United States of America. That's the law. One is actually the law being laid down, that's declarations. The other two are ordained or established, or ordained and established. So that in a nutshell is what you need to learn first. If you don't know that stuff, you're not going to be able to tell that this is unlawful. You're not going to be able to tell that this is color of law, color of statute, right? And one last thing. I just got to pop that up and show it to you. Get the law. Come on. I don't know why they don't, because they're trying to hide it from you. But I think they are supposed to publish it. So you might go down to your Capitol or make a phone call. Maybe they can mail it to you. It should be in print. I'm going to go right down here to 242 or 241 and 242. There we go. So we got conspiracy against rights. That would be the two or more conspire, right? So your social worker and the peace officer, supposed to be peace officers, keeping the peace. Conspire to injure, oppress, threaten, or intimidate any person in any state, territory, commonwealth, possession, right? And the free exercise or enjoyment of any right or privilege secured to him by the Constitution and laws of the United States. Okay, let's go to 242. Whoever, under color of any law, statute, ordinance, regulation, or custom. What? That's right, because statutes, ordinance, regulations, they're all color of law. They're not law. In any state, territory, possession, district, deprivation of any rights, privileges, or immunities secured or protected by the Constitution or laws of the United States, or different punishments, pains, penalties on account of such person being an alien, color, Where is that? Maybe it's section, or did they get rid of that? Wow, it used to say out on the streets in disguise. Oh, here it is. If two or more persons go in disguise on the highway or on the premises of another with the intent to prevent or hinder his free exercise or enjoyment of any right or privilege so secured. That CPS worker with her little badge, that's a disguise. Those alleged peace officers that are with her, or him or her social worker, that's a disguise. They're on the premises, on your premises. That's a violation of the law. And if it involves kidnapping, if such acts include kidnapping or attempt to kidnap, even attempt to kidnap, may be sentenced to death. That is a capital offense, punishable by death. That's how serious our law really is when it comes to depriving people of their rights. And if it includes kidnapping or even just an attempt to kidnap, you may be sentenced to death. So, with that, folks, much love. We'll see you Wednesday night. And we'll be discussing more on John Gentry's petition of remonstrance. I'm pretty sure that's going to be a subject that we'll be talking about on Wednesday night. So much love to you folks out there. Thanks for tuning in.